Welcome to today's maintenance webinar, which is hosted in the Western Cape. I'm Nicole Africa, and I'm the Deputy Director for the Sexual Offences and Community Affairs Unit. It's a unit within the National Prosecuting Authority. I will be the moderator for this session, and I have with me today my colleague who will be presenting, Advocate Dion Freitas. He is the Senior Maintenance Prosecutor and he's responsible for the maintenance portfolio in the Western Cape. He will be sharing his presentation on the civil enforcement of maintenance orders, where respondents default on their maintenance obligations. He will also take you through the process in respect of the maintenance forms to be completed, and also where an applicant submits a J470 complaint form, and where the applicant applies for the enforcement of the maintenance order on a J306 form. You'll also be sharing some information on the criminal prosecution of maintenance defaulters. There will be an opportunity for all of our viewers as well as our colleagues and teams to be able to ask questions once he's presented on all of the information. And if for some or other reason the viewers are not able to communicate with us directly, we have made available a platform where you can send your questions to the following email address. It will also be on the social media platform and on the Teams chat. You must send your questions to communication@npa.gov.za and we'll be able to respond to you in that fashion. I will now hand over to Advocate Freitas, who will continue with the rest of the webinar. Thank you.
Good morning to our viewers. My name is Advocate Dion Freitas. I'm the Senior Maintenance Prosecutor for the Western Cape. I am a family of 11 senior maintenance prosecutors over South Africa, and I represent the Western Cape. Last week, you've heard of the Gauteng Senior Maintenance Prosecutor, Advocate Alexander Tusha, my sister in Gauteng, and she took you to some of the important points in the Maintenance Act. Today, I'll be focusing on the civil enforcement of maintenance matters, but just as an introduction, I thought it's important that I set the scene, and I would like to set the scene by showing what some of my colleagues have done and have been giving some information in the last few webinars that we've been hosting. Please note for our online viewers as well as some of our applicants in the maintenance courts, if you'd like to see recorded versions of the sessions, you can go on YouTube, and if you on YouTube put in maintenance awareness webinar, then you'll be able to be directed to our specific platforms where you can get information on the different aspects of maintenance that you'll deal with. My presentation's got a lot of QR codes from the first slide up to the last slides. So please keep your cameras on. If you have a good QR code reader, please make sure that you keep it on, and then you'll be able to scan and download all the forms that I will be dealing with today. So it will just be a quick and easy way for you to be able to get all of that. In a case where I move a little bit too fast and you can't get to scan that specific QR code, don't worry, you will be able to get an opportunity at the end. At the end of my presentation, there is also a copy of the full presentation that you can then download. On the first slide, it also says that you can just put your phone towards the screen wherever you're sitting, or close to your television screen. Just put your phone to the screen and you'll be able to download any of those presentations and the forms that are next to the QR code that you'll be seeing with. So, setting off the scene, the applicant came to the maintenance court and she is applying for maintenance. And the first documents that you will always be will encounter is the J101 and the J107. The applicant will either complete a J101 or J107. I will explain the J107 a little bit later, but that QR code on the second slide, that is for a J101 you are coming to the court for the first time and you are applying for maintenance, we get the parties before court on what we call a Regulation 3 directive, or we will use a Section 9 summons depending on who we need to get to court. If it is a banking institution, then we use a Section 8 subpoena that we will then be able to summon the bank to come and give bank financial statements or whatever else we might need in that specific case. Once we've got the parties to court, then we will start what we call, in terms of Section 6 of the Maintenance Act, a Section 6 informal inquiry. Once the informal inquiry is done in front of the maintenance officer, we can then either move to a Section 10 inquiry in front of a magistrate and then conclude the maintenance matter in our maintenance courts. By the way, there are 454 maintenance courts in South Africa, that is excluding the satellite courts. In total, we have over more than 500 maintenance courts in South Africa if we also concentrate on the satellite courts. In the Western Cape, we've got 57 maintenance courts and a few smaller satellite courts, but the main maintenance courts that work every single day with maintenance is 57 in the Western Cape, dealing with these maintenance matters. My colleagues have dealt with how you calculate the expenses of the miner, how do you calculate the contribution that the parent must make, and all of that is dependent on the means of the specific person, whether it is a father or mother. Both of them can contribute to the maintenance of that specific child. Then the maintenance inquiry can be done by a maintenance officer from the Department of Justice, that's in terms of Section 4.2 of the Maintenance Act, or by a public prosecutor in terms of Section 4.1 of the Maintenance Act. And both these maintenance officers or a prosecutor can lead a Section 10 maintenance inquiry before a magistrate, whichever the case might be. So what are the forms that are usually required by the maintenance court? On slide 3, I show all the different forms that is needed. A certified copy of your ID document or your passport, as well as copies of the birth certificates of the children, bank statements. If you are married or are married, a copy of your marriage certificate. If you're divorced, copy of your divorce order. All of those are the documents that is important whenever you're gonna then come to the maintenance court. I said in the beginning, you can also get a J107 form. Usually the maintenance clerks in the maintenance court will ask you, are you there for a first time? It might be that you are accessing the maintenance courts for the first time, but that doesn't mean that there's no order in place, especially if you have been divorced. In the event where you are a divorcee, then the J107 form is the form that you will be be using on slide 4. So the J101 is always for a person that comes to the court for the first time, and if there was a order being made previously, then you will complete the J107. If you are a divorcee or you have a parenting plan that was concluded by the children's court, then you can use the J107 form. If you've been in the domestic violence court, and in terms of Section 7, the domestic violence court can also give emergency monetary relief orders. And then if you'd like to have that order amended, you can do that on a J107 in the event where you need an increase in that specific order. Then you do that in terms of Section 6. With the J107 form. Slide 5, I just then also just give a summary of what have been discussed by some of our colleagues in the other provinces. The position regarding 18-year-olds have been discussed in previous webinars, and the current Supreme Court of Appeal decision of Z versus Z and the George Circuit Court case of DWT versus MT. You are also aware by now that you can claim witness fees, your taxi fee, for coming to the maintenance court in terms of Section 11.1. So whenever you are incurring expenses, then you will be able to be able to get subsistence and total allowance from the court. If, as an applicant or respondent, you need an increase, the J107 will be used. And if you can't meet your maintenance obligations, you can do so by completing the J107 and requesting the court for a reduction in that specific maintenance order. In our future webinars, we will touch on international maintenance matters and the AEMO legislation. We will in future deal with that specific legislation and how people can access international maintenance where the applicant or the respondent is living in a foreign country. Slide 6. Which courts can make an order? As I said, it doesn't not just need to be a maintenance court that makes a maintenance order. Divorce courts already make those orders. The High Court, Rule 43 orders, the Original Court, Rule 58 orders, and then final orders by the divorce courts, whether it's the High Court or the Original Court. Domestic violence courts, in terms of Section 7, can make emergency monetary relief orders. The Children's Court can make Section 33 parenting plans with a Section 33, subsection 3 maintenance clause, or Section 161 contribution orders are all of the different courts that can make these type of orders. Even in the event where a person appears in criminal court, the criminal court can make a bail condition that the specific accused pay some of the expenses of the family member that he might have been committed a criminal offence against, for him ending up in the criminal courts, whether it's in the sexual offences court or wherever it might be. Then you will be able to be eligible to pay maintenance in any of those type of cases. Slide 7. Petition, different types of consent orders that can be made on a J214 consent order, and those orders can be made by attorneys or whoever is dealing with that specific case. And even in the event where the respondent is maybe living in a foreign or in a different province, then they can complete the J214 order and send it to that specific court in another province. My colleague and I dealt with one case between Durban and Cape Town where my sister Nokokanya Kwabaza was sitting in Durban with the respondent, and I was sitting in Cape Town with the applicant, and we were able to, in that specific case, make a J214 consent order while the parties were in two different provinces. So there are ways that we can deal with these type of matters whenever there is a problem as far as distance is concerned or whatever the case might be. Slide 8, I include an important issue that most people sometimes forget to touch on, and that is lying in expenses. The colloquial word is back pay. To get money from the respondent in the event where he or she did not contribute to maintenance for a considerable period of time, then in terms of Section 16 of the Maintenance Act, you can go back to the time when he stopped paying, and the Act is even so clear, you can go back right to the date of birth in order to deal with that specific matter, and then request back pay in terms of Section 16 of the Maintenance Act. I have a QR code over there. That's an article that was published in the Darabas of December 2022 by a colleague of mine in the Western Cape, Ms. Roxanne Jansen. She wrote an article on lying in expenses. So if you want to get more information on lying in expenses, please read the article of Ms. Roxanne Jansen on lying in expenses or back pay. Another important point is that whenever you enter the maintenance court, please ask for an interim order to be made after your first appearance, and both applicant and respondent are at court. Then you can ask the court to then make an interim maintenance order in the event where you have to come back at a later stage or next month or whatever the case might be, you can ask the court for an interim maintenance order. In the event where the maintenance officer do not even consider, then ask him that he takes you to the magistrate, where you will be able to then request interim maintenance in that specific case where there are no maintenance order in place. That comes to our session for today, and that is dealing with the defaulting respondent. So now there is a court order that was made by the maintenance court, and that is the J214 consent order that was signed, or what we call a J168 court order. Any of these can then lead to the respondent defaulting on his maintenance obligations. So the starting point is the complainant or the applicant who got the maintenance order should then apply for or complain on a J470 complaint form. This form will be completed by the complainant, and she will then say whether he's got assets or whether he's got a pension fund or whether he is working. In the event where he's working and he's got some type of a salary, then we can slide 11, or we can then use a J306 enforcement form. This form we use in order then to claim the salary, garnishing order, or to claim assets in terms of Section 27, or we can even then attach his pension fund or retirement annuities in terms of Section 30. We call it an attachment of debt order. All of those are indicated on the J306 with those arrows that are shown over there. And if you would like to get a copy of the J306, just point your phone towards the screen, and you'll be able to get a J306 downloaded onto your cell phone if you press open link. The Act says that in the case where you would like to get that order enforced, the applicant must be in arrears for a period of 10 days. My colleagues all over the Western Cape, as far as the Deep South, Simonstown, Advocate Goliath will tell you the rule of law says you need to comply with the order as per the clauses of the order and not wait 10 days. In the event where the respondent wait 10 days, that's a form of misconduct that we can prosecute in terms of Section 31(1) of the Maintenance Act. So you cannot wait for 10 days, and some of the respondents, male or female, will say, no, I've got 10 days grace to pay. There's no such thing as grace to pay. The children need to eat, so you need to make sure that those children get that money on time as per the letter of the law. And the rule of law says you need to comply with the order and not wait for 10 days because you have heard from your attorney or whoever that you do not have to comply with it immediately. You can wait 10 days. In the Western Cape, we do not apply that rule. We will make sure that we go according to the letter of the law, and the rule of law says comply with the order as it stands, else you are eligible to be prosecuted in terms of Section 31(1) of the Maintenance Act for non-compliance with it. I will deal with Section 28(1)(d) of the Amendment Act a little bit later, because there's an important point that I need to discuss when we get to that specific point. These proceedings, when the lady complained on, or the applicant complained, will either be the J470, J306, and then the court process behind the scenes is where we will start either motion proceedings or we start ex parte proceedings. In most cases, magistrates would like to have these civil attachments being done in terms of motion proceedings, but Section 28(1)(d) of the Amendment Act 9 of 2015 has a different provision where we are allowed to do ex parte applications, and I will get to that in the next few slides. So what's important that you need to know is when there's defaulting action, you complete the J470 and the J306 forms, and once you've completed that forms, you submit that to the maintenance court, also with the calculation of the arrears. Please do not come to the maintenance court and say, I don't know how much is in arrears. You need to know how many months is skipped, and based on the court order, what is in arrears, and therefore claim that amount. Once we know what the amount is, then we can start with our investigations, or the Department of Justice's maintenance investigate in terms of Section 7 will start with their investigations. We'll look at things like his ITC financial records to see whether he's been entered any credit agreements. We will look whether he's got any cars or on the e-notice system, and we can summon his bank accounts in terms of Section 7 of the Maintenance Act. So all of these investigations can happen behind the scenes once you submitted your J470 and your J306 forms, and we will specifically look whether he's got assets, and you are the applicant or the complainant is our best form or source of information. Tell us whether he's got assets. Tell us whether he's got a permanent employment. Tell us whether he's got a pension fund. Tell us whether he's got a retirement annuities or whatever else he's got. That way we will be better equipped to then decide which way we're going to attach, whether it's going to be a Section 27 attachment of any of his assets, which is usually immovable that we start with, and then we start with movable assets, and then we will look at garnishing orders in terms of Section 28, and the last Section 30, we will look at retirement annuities or pension funds and whatever we can then in that specific case then attach. And as I said, it's either motion proceedings or ex parte proceedings. In most cases, courts will use motion proceedings for Section 27 and Section 30 attachment orders. Unfortunately, it spilled over to Section 28 attachments in terms of emolument attachment orders, but there is no provision in law that says that it must be motion proceedings. It can also be ex parte proceedings in terms of Section 28(1)(d) that the court can use in those specific cases. So coming back to Section 27, Section 27 is the attachment of assets. So we will start off with immovable assets, movable assets like cars, television sets, or bicycles, quad bikes, or whatever else is good. So give that information to us when you submit your J470 and your J306, and then we will then decide whichever is the assets that we can then attach. And that we will usually do in terms of motion proceedings, because we need to find out if that specific asset is not encumbered by a third person. Encumbered by a third person meaning that somebody else also have ownership over that specific asset that we would like to attach. So what then will happen is the warrant of execution will be issued by the court, and the maintenance court will give a copy of the warrant of execution to the applicant. The applicant will take that to the office of the sheriff, and the sheriff will then go to the respondent's property or his house or wherever he is and see what assets there are that we can employ. If the applicant cannot afford to pay what we call the sheriff security fee, because the sheriff is not going to do it for free, he needs to also eat, so therefore he is going to claim sheriff security fees in order to sustain his office as the sheriff in that specific town. So therefore he have a fee attached to it, which most people don't tell you. So whenever you apply for a Section 27 attachment of assets, please, the maintenance officer should inform you that there is a fee attached to it, and that fee is in terms of Section 27 of 2 of the Maintenance Act. The Department of Justice have a policy document called the Department of Justice Family Code 26 of 2015. And in that code, in paragraph 40.1.5, it says that the maintenance officer should do an inquiry and find out whether the applicant can afford the sheriff security fee. In the event where where the applicant cannot afford it, then the applicant can ask the court to, in that specific case, then assist him or her to get the sheriff security fee paid to the sheriff, and then afterwards claim it once an auction have been done where the assets have been auctioned off. Then the office of the court can then be reimbursed in those specific cases. So please make sure that you do not leave the court with a warrant of execution and you know you can't afford it. In some of the cases that I've dealt with, it's an amount of around 5,000 to 6,000 that the applicant will have to pay to the sheriff in order for the sheriff to go and write up the assets of the respondent and then afterwards to go and sell that specific assets wherever the auction will be held later on. I know in the Southern Cape in Oudtshoorn, Magistrate van Harte is somebody that quickly on application by Mr. Johnny, the maintenance officer, will easily grant an order that the court will have to pay the sheriff security fees. I know it's not being done in the Northern Cape, but some of the provinces will then be able to get an order from the court that the court will grant the order to then pay the sheriff security fee, and at a later stage that fee be reimbursed once the auction has been completed. In the event, Section 28, where the salary of the respondent is being attached, there is this proceedings in terms of Section 28(1)(d) that I would like to mention. The Amendment Act 9 of 2015 says that and as I said earlier, there's either motion proceedings or ex parte proceedings. In the event where, as I said, most courts prefer motion proceedings, but there's nothing that stops a maintenance court from doing an ex parte application. And where an ex parte application can be done, all the applicant needs to show is that giving the respondent an opportunity to be notified of that specific attachment order of his salary will cause an unreasonable delay, and it will be to the detriment of the children that he or she needs to look after in those specific cases. So there is nothing that stops a maintenance court from making an ex parte application, despite what I said earlier, that maintenance court prefer that it be motion proceedings. There's nothing that stops a maintenance court from doing an ex parte application based on the provision in Section 28(1)(d) of the Amendment Act 9 of 2015, where the specific employer as well as the respondent will be given an opportunity of 14 days in which they then can come back to court and then oppose that application. We in the Department of Justice, as well as the prosecutors that assist, once the garnishing order is made, then we have to give within 7 days notice to the employer, and we do that notice on a form called a Form O or J448, and there's a copy of the J448 on the right-hand side that you can scan in, just for you to have some idea how it looks like. This form is completed by the maintenance staff, in which they will then make it clear that the employer will be informed. We have some problems as far as making sure that this form is duly done within a period of 7 days, especially if the employer is in another province or in a distant town. Then it is difficult for the maintenance staff to comply with this provision of serving this document within a period of 7 days, the J448. I am a proponent and I am in favor of us using substitute service via email, even though the Maintenance Act do not provide for it now. Regulation 26 of the Maintenance Act only provide for us faxing the Form O to the employer. It doesn't provide for substitute service via email. But Section 46 of the Maintenance Act says, in the event where the Maintenance Act is silent on any provision, we can always cast reference to the Magistrates Court rules. And in this specific case, we can use Rule 9(9) of the Magistrates Court rules, and then bring an application to court in which we ask that we then do substitute service and serve that specific document via email on the employer in those specific cases where the employer is distance away from us. I've seen on some social media groups that there are some attorneys and some applicants struggling with employers not enforcing these orders. And yesterday I saw on one of the groups that employers refuse to enforce these type of orders. Whether there are any of these type of cases that the employer do not adhere to that specific order, then the maintenance court have one of two ways to deal with it: Section 29(4) or Section 38. Section 29(4), we can take the employer's assets, or we can even attach that money in the employer's bank account if need be, in order to claim that specific amount that the employer is in default of paying over to the applicant. And we complete a form called the Form L. And if we feel like it, we can prosecute the specific employer and the respondent, and that we do in terms of Section 38 of the Act. In the event where the specific person intentionally resign from his employer, we can even attach his UIF benefits, and that we do in terms of Section 33 of the UIF Act. That UIF benefits can be attached for the purposes of maintenance. We've had a case in Bellville quite recently where the Bellville court gave us an order to attach the UIF benefits of a respondent. So if I can leave the viewers with one thing, UIF benefits is attachable in terms of the UIF Act, and we have had some of these cases in the Western Cape where we attach UIF benefits. So Section 30 attachment orders is where we can take the pension fund or the retirement annuity of the respondent, and that we do in the event where he either resign from his employment or resign from her employment, or where there is a retirement annuity that we can attach. But that doesn't mean that's the only thing, only pension and retirement annuities. If it is a person that have their own business and they've got clients, then we can use that contract between the clients in order to attach the money that is due and payable to him, or in order to then extinguish the maintenance debt. If she is having a taxi business, there's nothing that stops us from approaching the contracts that the taxi business have and attach the proceeds of coming to fetch the children to school or to get the employers back home. That taxi agreement can be attached in order to then make sure that the applicant or the complainant in that specific case do get the benefits of these civil attachments. In most cases, it will only be done in the case where the person is in arrears. There is a Western Cape decision, Gerber versus Gerber, that says that in any event where the future rights of maintenance rights of a child is at risk, then we can also attach. And that's what happened in the matter of Gerber versus Gerber. Mr. Gerber came to court and said, how can you attach the sale or the proceeds of sale of us selling this house? I'm not in arrears, I've been paying my maintenance, so why are you doing that? And in this specific case, the Western Cape High Court found that if there's any danger to the future benefits or the future rights of a child, in those cases, even if it's not in arrears, we can, in those specific cases, then attach that benefits. And in this specific case, it's not a retirement annuity, it's not a pension fund, it's the proceeds of selling a house that was attached in the Gerber versus Gerber case. The Solar versus Solar case is our locus classicus whenever we deal with future maintenance, and we in the maintenance court can attach any amount, even if it's beyond millions, which the regional court do not have jurisdiction, but the maintenance court has got extraterritorial jurisdiction to even then attach millions in a specific fund, wherever that is, and we are dealing with it. We can also then take the pension funds, and in that specific case, what's important is the way we cite those specific financial institution. And in most of the case law out there, we will find that if you do not cite the respondent properly, then you might have a problem. So attorneys, make sure that you do get the right citation for those specific funds in a case where you are involved in a Section 30 attachment of deed. There are some financial institutions that do not want to work with the Department of Justice's Moja Pay. In that specific case, you can pay it, you can cite the fourth respondent as the master of the High Court in the event where the financial institution object to paying into the Department of Justice's Moja Pay account. Then I always prefer to cite the master of the High Court as a third or fourth respondent, whichever the matter might be. So whenever we deal with these cases, the respondent also has different recourse, and these recourses is in terms of Section 27.3 as well as in terms of Section 28 for the employers. Section 27.3 says that in terms, if the respondent is not happy with the execution order on his assets being attached, he can approach the court within 14 days and ask, please don't take my Porsche. I am willing to pay that year amount. And that is what happened in Hermanus a few months ago, where my colleague, Mr. Mandelakir Zweni, got an order to attach a Porsche in Hermanus. And when the respondent found out that they're going to take his prized possession, he immediately approached the Hermanus court and told the court, no, please do not take my baby. I am willing to pay the area amount, and he paid 120,000 immediately, but nobody's going to touch his Porsche. So there are some means for a respondent to approach the court within a period of 14 days and say that please don't take this, this is what I'm willing to do. Then the maintenance court can amend or then rescind that specific execution order that was granted. In the event of the employers, in terms of Section 28, they can complete a form called the J438 and say that my employee do not earn this amount of money that you are claiming. Can we look at a different amount that we can comply with? If there's non-compliance, Section 29.4, Section 38 says we can prosecute the employer in the event where they do not comply with the order. In the case of Section 30, where we attach pension funds, retirement annuities, or we would like to take the proceeds of sale of a house that are being sold after divorce, then in all of those cases, the respondent or the banking institution can complete the J458 within 14 days and say, no, please do not attach the pension fund, please do not attach the retirement annuity, and that is being done on a form called the J458. So it's a J435, 438, and 458. Those are the forms that are out there and available to the respondents. The one that the NPA is involved in the event where there are non-compliance, we can prosecute those matters. We can prosecute a parenting plan that is not complied with in terms of Section 33. We can prosecute a Rule 43 order that is not being complied with. We can prosecute a Rule 58 order, a regional court divorce interim order that is not complied with, and that we can do in the criminal courts in terms of Section 31 of the Act. In the event where we decide to prosecute, we can prosecute for whatever amount, even if it's in millions, we can prosecute that specific case. I mentioned VDB versus VDB and Stanley. In this specific case, it says that respondents do not have an automatic right to be notified in motion proceedings of every single thing. So that is the case that the maintenance officers use a lot whenever we deal with these type of matters, and the respondent say that they didn't receive notice. There is another case that I didn't include in my notes, Sibeko versus the securities. In terms of Sibeko, it was found that the sheriff or the maintenance investigator, can serve that specific court order on a security guard, especially where respondents are hiding in estates or are hiding in the employer's office. Then we can serve that on the security or the receptionist at a specific company where the respondent is hiding behind any of those. If we prosecute the locus classicus state versus Magagula, all we need to prove is that the accused had a guilty mind and there was a lawful court order that he didn't comply with. Then we can then prosecute that specific case. In the event where we secure conviction, instead, in terms of state versus Gideon Visser, a first offender can be sent to jail. So Mamasbury case, in which it was found that we can send first offenders to a period of imprisonment. So those that do not comply with their maintenance obligations should take note. In the event where they do not comply with their maintenance obligations, a first offender can be sent to jail. There's another case, State versus Potgieter, and my colleague at this local Western Cape DPP office, Mr. Stephen O'Bain, dealt with the matter of State versus Andre Potgieter. In the case of Mr. Andre Potgieter, he was also sent to a period of direct imprisonment for non-compliance with his maintenance obligations, even though he was a first offender. In terms of Section 31(4), we can then also do the blacklisting of those offenders to the credit bureaus, and that we do on a form called the Form W, where we can put all of that person's details and report that to the credit bureaus, including TransUnion and all the other credit bureaus that is in South Africa. We also prosecute the employer or the respondent in the event where they give false information to the maintenance court, and we can also prosecute them in the event where we find out that they are delaying the system or hiding behind us having to serve documents on them. And that's why I quoted VDB versus VDB and Standard in the event where we find that they are hiding in order for us not to get to them. So the point is, there's no ruling law that a first offender can't be sent to jail, and that is in terms of State versus Gideon Visser and State versus Andre Potgieter. Those cases make it clear that the NPA can prosecute in the event where there are non-compliance, and even in the event where there is compliance within the 10-day period. It's a form of misconduct, and we can then still decide, even if he will say, but I did pay it on the 9th day of the 10 days, that's a form of misconduct, and we can still prosecute in any of those matters whenever it comes to prosecution of these matters. I would like to end off to say thank you for all those online viewers that are listening. Please ask as many questions as you want. I try to make sure that we've got till 11:30 that we can get some of these questions. So please, if there are questions, you are open to ask. Thank you.
Good day, sir. It's Colonel Naidoo speaking from Cairns River Police Station. Thank you for that presentation you've given us. Is it possible for you to email that presentation to our principals at the PC's office that we can have a copy of the presentation, please? Thank you.
Yes, the presentation will be emailed after the webinar to everyone in the meeting. Thank you.
Thank you.
Colleagues, we also have 2 questions that were sent through on our social media platforms for advocate voters. The first one is the interim maintenance order enforceable?
Yes, an interim order is enforceable if there's non-compliance with an interim order, whether it is an interim order that is made in terms of Section 10(6) of the Maintenance Act, whether it's an interim order that is made by the High Court in terms of Rule 43, or whether it's an interim order made by the regional court in terms of the Rule 58, any of those orders can be enforced via the Section 26 civil attachments that I mentioned, or via criminal prosecution. It is up to the applicant as well as the maintenance officer and the prosecution which way to go. If there are assets, we usually, and my colleague in the KwaZulu-Natal province of Pietermaritzburg, Advocate Stefanie Erasmus, will always tell you we first go after the money. So we will first see in terms of Section 26 whether we can attach assets in terms of Section 27, or if he's employed, if we can use Section 28 emolument attachment orders, or if we can use Section 30 and attach any of his pension or the retirement annuities.
Okay, thank you. We also have a question from, it looks like Ms. Dani. What process do we follow when the maintenance officer simply do not want to hear the part where the applicant has no visible means of support, and will it be a hardship if the amount is not increased?
In terms of Section 6, there must be good cause shown. So, Ronnie, in that specific case, there must first be shown that there is actual needs for the child. If that is shown and the maintenance officer do not want to listen to you, Section 6 of the Act says you can approach the maintenance court, that is the magistrate, and you can ask for Section 10 inquiry being done by the magistrate. In the event where the maintenance officer is blocking you from getting to the maintenance court to then deal with it in the Section 10 inquiry, at the entrance of all courts, there is an information board with the details of the court manager, area court manager, director court operations, and the regional head. Get that details. Send a complaint to all of those people on that information list and tell them that the maintenance officer is blocking your access to the magistrate in the maintenance court to have a Section 10. But the maintenance officer might be within the ambit of the law, because Section 6 says he may refer to the magistrate for Section 10. It is not compulsory that every single case that you or the respondent is not happy with have to go to the maintenance courts. In some of these cases, we can then say that no, but there's no good cause shown. So your magic word or your key word is there must be good cause. There must be voldoende rede in Afrikaans. You must show why you need that specific increase. Increase can be because your Rule 43 says that every year in terms of CPI you're entitled to an increase, or there is a financial change where you move from one house to another house, or the children move from one school to high school. All of those drastic changes in finances and that will have a financial impact can be seen as good cause. So if you find that you've shown good cause, there's absolutely no reason why a maintenance officer can block you from then accessing a magistrate and putting your case in front of the magistrate. So if there's some of these non-compliance or maintenance officers blocking you, report it first to the court manager. And then if the court manager is not there or is not listening to your complaint, then you can report it to the regional court manager. And if the the court manager is not there, then you can report it to the director court operations. If the director court operations is not of assistance, you can report it to the regional head. So that is the protocol or line of reporting that you can do. First, report to the court manager, area court manager, director court operations, and then you can get to the regional head. If you still don't get any benefit from any of them, there is a complaints line called service delivery, one word, service delivery at justice.gov.za. You can file then a complaint against the specific province at the national office, where they will then deal with your complaint in the event where a maintenance officer do not want to give you an opportunity to deal with your case in a Section 10 inquiry. Thank you.
Thank you, Advocate Ritus. We'll now take a question from Ms. Andrea Julius.
Hi, Council. Can you hear me?
Yes, I can hear you.
Okay, so my maintenance, it relates to my own children. So I am based at Legal Aid in Pretoria, and then baby daddy, I'm in Uppington, baby daddy is in Pretoria. So he received the subpoena, but then the court in Pretoria said he refused to sign it. So now the maintenance officer in Uppington can't give me a interim order, but baby daddy was at court in Pretoria on the last appearance. So what do I do in that instance?
Well, if there is a proper return of service and he knew about it, there's nothing that stops the court from dealing with the case. And he can't refuse to sign. There's no such thing as refusing to sign. The Maintenance Act says that in the event where he in any way hamper the process that is followed in the maintenance courts, he can be prosecuted. It's actually a criminal offense not to sign it. So in that specific case, I'll speak to my colleague in Uppington, Mr. Oden. I will contact him after the session. I've got his details and find out why they didn't, in that specific case, make a default order. J252 default order could have been made in the event where the sheriff on the return of service indicated that the respondent did not want to sign. In the event where he doesn't want to sign, then we can then deal with him in a criminal court. We can prosecute him. And number two, you can get a J252 default order by now in the event where you knew about the maintenance action against him and there's non-compliance with that specific order in that specific case.
Okay, that would be great because my case is a bit complicated. He's one of those entrepreneurs, but now he actually threatened me. He's upset that I took him to court. So now he's threatening me that he's going to reduce the maintenance from what he's currently giving me. And then the other question is also his main income is from Treasury, but I know he's hiding assets in a trust and most of his assets is in the business name. So is it then possible for you to then contact Treasury to find out what is his annual revenue that he makes from his businesses from Treasury, and based on that, calculate how much maintenance he can afford to pay?
Yes, we can. In terms of Section 7, we can do, the maintenance investigator can do all of those investigations. Treasury is a little bit difficult, and SARS don't play with us. I do not want to give you hope and say that we are going to get I tried a few times to get information on some of these tenderpreneurs that have these contracts with government. But in terms of Section 7, we can investigate and we can get all of those type of details pertaining to that specific case. All the maintenance investigator need to do is then just complete a Section 8 subpoena and serve it on Treasury and say that we want to know which of these tenders did he bid for, where's his bid applications, what did he bid for, and obviously some of the information of his financial interests are declared in there. We can also look at his bank statements because his bank statements will show what Treasury paid into his account over a period of time. So we will be able to get that information on previous contracts with those specific cases. I will liaise with our Northern Cape or my Northern Cape counterparts pertaining to your case. Once we get all the details, if you can leave your details with us, then I will liaise with our counterpart in the Northern Cape for your specific matter.
Okay, thanks. That would be great. I did leave my email on the chat box.
Thank you.
Okay, thank you very much.
Thank you, Council.
We have a few more questions that were also sent via Teams and on social media. The next question is from Lilama. How would you approach a matter involving a foreign nation who is a respondent and it is alleged that he is a financial position to pay. He's self-employed but doesn't have a bank account.
Depending on which the foreign country is, in terms of the REMO legislation, Act 80 of 1963 and Act 6 of 1989, those two pieces of legislation deals with international maintenance. So depending in which foreign country is, South Africa have a international treaty with some of these countries, not all. So if he is in a country that have a reciprocal treaty with South Africa, we will be able to then deal with him in the specific country that he is in. All you need to do is get to your local magistrate's court, complete the forms pertaining to the REMO matter. You will do a normal J470 where you complain that he's not complying with the order. The court will make an interim order. That interim order will be sent to the reciprocating country, and that we do via diplomatic channels. We send it from the court to international relations in Pretoria. From international relations, it goes to DIRCO. From DIRCO, it goes to wherever the country is where he is staying. If we have a treaty or an agreement between that country. If we do not have an agreement in terms of our REMO legislation, then we can use Section 27 and 26 of the UN Convention on the Rights of the Child if there is a treaty between South Africa and the specific country where he is. I will advise you to approach your local maintenance court. In terms of the DOJ Code 26 of 2015, there's approximately 38 pages devoted to international maintenance in the code. The code is specific what forms must be completed, and all our maintenance staff have been trained by the NPA as well as the Justice College in terms of international maintenance matters and how to deal with it. If you have any specific query or problem with it, we are 11 senior maintenance prosecutors in South Africa. Approach your local director of public prosecutions and ask who is the senior maintenance prosecutor. All of us are well versed in international maintenance, and we will be able to assist you in that specific regard to get your case sorted out.
Okay, thank you for that. We also have a question from Marina. The maintenance court did the application to attach the pension fund of the respondent, but the money was never paid, and the respondent was paid out by the employer, in this case was Pick n Pay, and all his pension benefits were paid out to him. He knowingly resigned. This was done willingly. The maintenance officer, according to Marina, is failing that.
In terms of the Anna Mutimunia, there's a case, Ms. Marina, there's a case, Anna Mutimunia versus the PP, the Minister of Justice in that specific case, where it says that where there was a Section 30 attachment of debt order saying that the pension fund must be attached, Pick n Pay must be attached, and it wasn't attached, after the order was granted, then you can claim that arrear amount as well as future maintenance from whoever let you down. But if there was an order and that order was not complied with, whether it is Pick n Pay or whether it's the Department of Justice, somebody needs to take accountability for it. So I am aware of your case. I've seen the communication. I am going to go to Kuilsriver Court in the next a few days to deal with your case. So if you can give me an opportunity to just peruse your file and then get to Kuilsriver Court, I'll deal with your case. I'm aware of your matter.
All right, then we have a question from Shadeen. Does the court give the respondent opportunity to pay the arrears before granting a garnishment order?
Can you just repeat the question?
So Shadeen wants to know, does the court give the respondent an opportunity to pay the arrears before granting a garnishment order?
What usually happens in our courts is the court will make an order based on the fact that he's in arrears. So if the monthly amount that is requested is 5,000 and there is still arrears, the court have the jurisdiction in terms of Section 16 to also include the arrears. So the normal order will be 5,000. He's in arrears worth 70,000, and of that 70,000, he should pay an extra amount except for the 5,000. And in those specific cases, the court will make the monthly amount plus a contribution towards the arrears in order to then purge the arrear amount that he still owed. But yes, the court will take that in consideration, but the court needs to know about it. Make sure that you are giving the court as much information as possible in order to then determine what your new maintenance amount is with a portion of the arrears, whatever he is owing in that specific case. But you need to give that information. And I always tell the applicants and complainants, make sure that you update it every single month that he is in arrears. Let us know what that amount is. But most of the applicants going to court say, but I've been to court 4 or 5 times, they know how much it is. Whenever we make that order, then you will only then want to run back to the court and say, no, but what about the arrears? So please update your arrear amount every single month that is in arrears. That way the court is having all the information and can make an informed decision on what the monthly amount should be, as well as what will be a fair and equitable, in terms of Section 15, a fair and equitable amount that can be added to that monthly amount to then purge the arrear amount.
Then we have a question from Tulebona. Good morning, panel. Can a person refuse to pay maintenance on the basis that the mother refused access to the child, or that DNA for paternity be conducted?
Now, he can't refuse. If there is already an order in place, he cannot refuse. If there's no order in place, then obviously then a DNA test need to be conducted in order to see whether he is actually the father, biological father of the child. In the event where he then subject himself to the court system, then we will conduct DNA tests. And once the DNA tests are known and it shows that he is the biological father, then as there's one slide online in expenses, then you can claim maintenance from the moment that he stopped paying maintenance until the day that the court made that order. And that's on slide 8 of the presentation that I did today. And then you'll be able to see how you can claim lying in expenses for that period. If it is from birth till the date that the court made the order, just make sure you keep a record of all your expenses that you've incurred on your own with no assistance from him. Then the court will be in an informed position to make a decision what the amount is for maintenance, plus what is the lying in expense, the back pay that you should get for that period. But no father can refuse to pay maintenance. There is a provision that we, as maintenance officers, always employ when dealing with matters where the respondent deny paternity. In that specific case, there is a provision in Section 36 of the Children's Act that says that there is a presumption of paternity. If the mother knows she's been with the respondent all the years, and in that specific case, he now comes and denies paternity, and there's a history that you can show that during pregnancy, he was there and he was supporting you and took you to the family or whatever the case might be, you can use that information in the maintenance court in order to then put your case forth that why is he denying paternity while he knew he's the father. If there's any problems as far as care and excess is concerned, Section 10(1) capital A of the Maintenance Act says if there's problems pertaining to care and excess, then the Office of the Family Advocate or a social worker can get involved to draft a parenting plan or care and excess arrangement in a parenting plan can be made by the Children's Court that will be informed by the maintenance application. But the Maintenance Act provides for care and excess arrangements in Section 10(1)A of the Act. in the event where he just plain deny or would like to have access but don't have access. But pertaining to paternity, the Maintenance Act can do the paternity test. You will have to pay for the test. The test is around 2,500 rand for him to pay. And on the day of the test, then what will usually happen is the applicant, which in most cases are the mother and the father, will be there, and both set of blood will be taken off the applicant as well as the respondent. It's just a fingerprint, and then they put it on a piece of paper, the blood spot as well as of the minor child. They will just do a finger prick and take the child's blood with the mother's blood and the father's blood, and then do an analysis. Our analysis is being done in Durban by MDS laboratories, and they usually, within a period of 7 to 14 days, will give us the results. And once we have the results, we'll take it back to court and then get the paternity test. If we know the paternity test and it is 99.999% that he is the father, then you can claim lying expenses in that specific case. I'm not sure if my last slide is still on. If the last slide is still on, then you'll be able to see my presentation, and you can copy that. Look at slide 8. There's a lot of information on lying in expenses and how you can claim that in the event where there is disputes pertaining to paternity.
Okay, thank you for that. And then we have another question from Nombuso. Good day. What to do if you apply for the spousal maintenance and the spouse doesn't pay at all, but he pays child maintenance?
If there's an order, and that's a divorce order stating that there is spousal maintenance that are payable by the respondent and he doesn't comply with it, then you can still file the J470 complaint and say that he is complying with the maintenance part, but he's not paying the spousal maintenance. You've got a clear-cut case, and it shows that he's got means to pay the child maintenance, but he's not paying the spousal maintenance. Take that matter to court, complete the J470 and the J306, and give us more information where he works, what assets he's got, and at which company he's working, so that we can determine where his pension fund is. And it's just a good way for us to flag him at the pension funds to make sure that in the event where in future he might resign or get retrenched or whatever, then the pension fund will be aware of him, and we will be able to then deal with him in that specific case. But the mere fact that he's already paying maintenance, child maintenance, shows that he's got the means to comply with it, with the spousal maintenance order. J470, J306, and your maintenance court will be able to deal with it.
Then we have a question from Rensha. The respondent will draw on his pension if possible to settle arrear maintenance, but disputes the amount in arrears as stated in the summons. Do I simply request further particulars before on the trial date to settle the matter? And then there's a further question, just sort of following on that. Can one request a remand for mediation?
Richard, pertaining to your first part of your question, yes, you can then deal with it. The amount that is in dispute, you can deal with prior to your court date. What I usually recommend is complete a founding affidavit where you explain precisely how you got to the arrear amount. If you can show this is the arrear amount that have been calculated, and to the exact T, you can show he's supposed to pay X and he didn't pay it. Here's my bank statements, it shows he didn't pay it. Or the schools, he didn't pay the school fees, or he didn't pay the medical, and how you came to that amount. Complete an affidavit before the time, and then tell the maintenance officer that you are willing to deal with your case via mediation or whatever the case might be. That is an option that is out there. So it's up to you what you feel like dealing with at that specific moment. But yes, you can get the information beforehand to the court and say, but this is how I calculated the area, what is now in dispute. And he will have to show that, no, the reason why I am disputing this area amount is because I paid X, Y, and Z. And they usually come with things that they paid the amount to the child, or they paid the amount to a family member. If that is the case, then if the court order says that it must be paid into your account and it wasn't paid into your account, then obviously you have a claim for that area amount. Show how you got to your area amount. Once you've shown how you got to the area amount, you will have to prove the opposite on the court date or whatever. You can anticipate that date and then deal with it in that specific case. In the event where you'd like to go for mediation, mediation is an option, especially where there are children involved. The Children's Act is clear that if there's any dispute between the parents, Section 21 is clear, then you can then ask that specific case of yours being mediated.
Okay, thank you very much for that, Advocate. It appears that we don't have any more questions either on Teams, either to ask Advocates directly or on the social media platforms. That's what I was doing. I was looking on my phone. So please don't think I was disinterested. It was just to be able to delay the questions to Advocates. So we are going to move to close this session. I just want to ask Advocates if there's any last word that he has before we have some the session.
We will be having more of these maintenance webinars. Please, on our communication at npa.gov.za. Please let us know if there's any other specific sessions that you would like us to cover in our webinars that we are hosting on the NPA portals. Then we will gladly have a specific session on whatever is some of the problems that you are encountering in the maintenance courts out there, and be able to then discuss your specific issue. I did discuss with my deputy whether we can, in the coming months, have a session on international maintenance, and then we might be able to host another session within the next month or two on international maintenance. But thank you for tuning in today. I see there's a lot of people that tuned in, and thank you so much for showing interest in the NPA maintenance webinars.
Thank you, colleagues, and thank you, viewers. As Deon mentioned, we are grateful that you were able to join in. I would like to just reiterate what you mentioned during this presentation, and whilst he was answering some of the questions that came through from the colleagues. Please be aware of your complaints mechanisms. Please don't feel frustrated with your processes. Unfortunately, some of the processes can take longer than one might anticipate, but I think Advocate has provided very practical remedies in relation to what you can ask for, what you can request, what you can apply for, and the immediate relief that you are entitled to in terms of the legislation. But if that relief is not forthcoming, then you can follow the complaints mechanism, and we would urge you to do so. We are a resource in the Western Cape as well through Advocate as the senior maintenance prosecutor in the NPA, and he does have an oversight role, and he supports the work that the Department of Justice does as well. That will only be sort of as a last resort, and just in order to be able to assist in overseeing the matters. He won't be able to get directly involved in all of the matters. And this is why we encourage you to use the complaints mechanisms and to ensure that your matters are dealt with appropriately. So we thank you once again for tuning in and for being available online, and we will see you at the next webinar. Thank you so much.